Good morning, everyone. I'm Howard Lerner, ELPC's Executive Director. I'm really optimistic about climate solutions, and this is really tough. There's not a lot of silver lining in the Supreme Court's West Virginia versus EPA decision, just more climate challenges and more hard work. We have one less legal tool to build necessary and vital climate solutions, but there are more tools and we're going to use them. No one ever said it was going to be easy to save the planet. So don't just agonize, innovate, litigate, and advocate. That's what ELPC will do, and we hope you all do. Keep fighting back. Don't give up. Our planet and our lives literally depend on it. Along with my colleagues, Ann Messnikoff, ELPC's Federal Legislative Director, and Senior Attorney Scott Strand, we're going to provide some analysis on what the court decided, how they did it, why it matters, what we think might come next, and what's happening in Congress. We'll be recording this webinar and streaming live on Facebook, so you can share it with friends who weren't able to join the almost 300 people today. If you have questions, please put them in the Q&A or the chat box, and we're going to do our very best to try to be able to react and respond to people's questions. All right. Let me summarize what the Supreme Court did in its opinion regarding the major question doctrine, what it didn't do, and why this matters going forward. Okay. The overall context is just plain bad. The Supreme Court's decision weakens EPA's ability to regulate greenhouse gases as climate change impacts worsen with more extreme weather events and the public's need for healthier, clean air gets more acute. The court overreached to take this case in the very beginning. Red states and coal companies challenged an Obama-era clean power plan that was not even being applied, implemented, or enforced. The court's decision, unfortunately, provides another legal tool for polluters to delay and stall sensible EPA standards to protect public health and healthy clean air for all of us. And while the public is calling for necessary action to deal with climate change realities, the Supreme Court is creating unnecessary barriers to governmental actions that are based on sound science and the longstanding Clean Air Act. So here's what the Supreme Court's 6-3 majority opinion did. It applied what it calls the major question doctrine to stop EPA from adopting the Clean Power Plan without a clearer statement of authority from Congress. The major question doctrine applies, according to the court, when there's an extraordinary circumstance, and the court says here an extraordinary public policy is involved. According to the courts, that's when agencies are asserting, and I'll quote, highly consequential power beyond what Congress could reasonably be understood to have granted. That's the view of the majority. The court says agencies have only those powers given to them by Congress, and we presume Congress didn't intend to shift the authority for making major policy decisions to the agency, but it wanted to make those decisions itself. So here's what happens. The court says, under our precedents, this is a major questions case, and the court criticizes the EPA for using Section 111D of the Clean Air Act as empowering it to, in the words of the court, substantially restructure the American energy market. What the court concludes is that EPA can't adopt this significant rule going beyond the fence line of a power plant. Okay. The fence line is, just think about it, big coal plant, lots of things going on at the plant, lots of piles of coal, lots of conveyor belts, coal ash ponds, and so forth, and a fence around it. The court recognizes that the EPA for many years has adopted regulations, whether it's for sulfur dioxide that causes acid rain, nitrogen oxides that cause smog, mercury, and so forth within the fence line. And what that's led to is for coal plant owners to install pollution control technologies to clean up their operations and to reduce emissions. The court makes clear that that's acceptable. Here, what the EPA did was actually try to give coal plant owners more flexibility by enabling them, for example, to invest in renewable energy projects beyond the fence line and then use them to, in effect, offset the emissions from the coal plant. So ironically, this was an EPA regulation that created more flexibility rather than less. The court says you can't do that. That violates the major questions doctrine. Let's talk about what the court didn't do and then what happens next, and then I'm going to pass it over to my colleague, Scott Strand. The court did not overrule Massachusetts versus the EPA, the landmark climate change case, and it didn't categorically rule out actions beyond the fence line, even though it expressed a good degree of skepticism about that. Maybe some of the utilities that filed amicus briefs convinced Chief Justice Roberts that that flexibility was important. But here's the four things that really ought to happen next in the legal context. First, US EPA should go forward with its necessary, important, and statutorily required rulemakings on ozone, particulates, NOx, sulfur dioxide, and greenhouse gases within the fence line. And keep in mind, when EPA regulates mercury emissions or sulfur dioxide emissions, that shifts the economics of continued operation of coal plants. Keep in mind, the Obama era Clean Power Plan was never implemented. Coal plants are shutting down because they're not economical in today's marketplace. Second, as my colleague Ann Messnikoff will discuss, Congress really does need to step up and act. It's time. Third, states should step up and act more strongly to protect our environmental health and public safety, while the Supreme Court installs roadblocks to federal agency actions. So for example, let's look at ways to revitalize Article 11 of Illinois' Constitution, which provides a right to a healthful environment. Let's look at ways for more states to adopt the California Clean Car Standards. Fourth and finally, industry should clean up its act and demonstrate corporate environmental responsibility to deal with the climate change problems that are the challenge of our generation. Right? Those are four things that should happen. All of them can happen following the Supreme Court's unfortunate decision in West Virginia versus EPA yesterday. My colleague, ELP Senior Attorney, Scott Strand, is going to talk a little bit more about the decision. Scott, ball to you.
Thanks, Howard. I think Howard gave everybody a pretty good summary of what the court did and didn't do. It's a bad decision. The verdict on whether or not it's a catastrophic decision won't be settled until the next few cases come. I do think it is important to acknowledge that right under the surface of the majority opinion is a number of justices who want to revitalize the old non-delegation doctrine. And instead of this just being a clear statement rule that if Congress wants to delegate broad authority to agencies, it must do so with clear language, and turn that essentially into a rule that Congress cannot constitutionally delegate broad authority to the agencies unless it has very specific standards. The two concurring justices, Justice Gorsuch, Justice Alito, made it very clear that that's where they want the court to go. And so it'll just remain to be seen whether they go that direction. It could be as well that this decision will stay more limited, that it isn't the death of the administrative state, as a lot of people have described it. There's a couple of things that clearly offend the majority of the court. When presidents come out and say, if Congress doesn't act, I will, the court sees that as an announcement that the president intends to violate the separation of powers, and that creates problems explicitly in the majority opinion, is the reference to President Obama's statement to that effect, and they found that offensive. The other thing they find offensive is when agencies use what they think of as old laws to find new authorities. And this really goes back to when the FDA asserted jurisdiction over the tobacco industry after 50 years or 60 years of saying they did not have jurisdiction over the tobacco industry. The FDA had new evidence, it had the old law, and they made a different decision. But there are a lot of people who never got over the idea that FDA took on that authority, and ultimately the Supreme Court rejected that authority. And that was really the precursor for this decision. A lot of this is a reaction to the tobacco litigation in the 1990s, when states used laws like antitrust, consumer fraud from early 20th century to go after the tobacco industry instead of the traditional kind of product liability theories that had always failed. So again, the Republican attorneys general who brought this case all basically got into office because of a reaction to those activities by attorneys generals in the past. So that's what we're dealing with. And if it's limited to those situations, Congress and others can manage that. We can try to avoid doing the things that are going to really, tick off the majority of the court, and maybe we can keep this decision limited. The dissent is not so sure that it can stay limited. I share their concerns about that. They make the point right off the bat, of course, that the court never should have taken this case. There is no rule for the court to review. The Clean Power Plan isn't in effect. The EPA is working on a new rule, but it's not done yet, and they should have waited until that new rule was adopted. The court came up, they said it's not moot, and they used a doctrine called the Voluntary Cessation Doctrine, which is the idea that when a party that's been violating the law voluntarily ceases unlawful conduct, it won't moot a case unless there's an absolute assurance that that unlawful conduct won't repeat itself. And that's what the court cited. But what's missing in the court's opinion is several decades of law saying that exception doesn't apply to the government. If the government says it's not going to redo conduct like a rule that's been challenged in court, we're going to give the government the benefit of the doubt. And we on the environmental side run into this all the time, where we will be challenging, for example, a Trump environmental rule. The Biden administration doesn't repeal it, but they say, well, we're looking at it, we're going to review it, and the courts have used that as a basis for dismissing the challenges as moot. So we'll see how that law develops, if that's going to change, or if this is just a one-off from the Supreme Court just to give themselves the opportunity to take this case. Of course, it's a discretionary court. They didn't have to take it anyway, and they shouldn't have. And that's really I think, a very serious blow to the role that courts ought to be playing to decide real cases and controversies, not to issue advisory opinions to agencies. On the law itself, I think Justice Kagan did a nice, admirable job of outlining how the Clean Air Act is supposed to work, why the exercise of authority by the EPA was well within what they've done in the past. The provision that they used is the one that applies to pollutants that are not listed in the Clean Air Act itself. It essentially says that if EPA finds that there's some other pollutant that poses a danger to human health and safety, they have the authority to regulate it, and they regulate it based on the best system of emission reduction. The language is is really quite clear. They haven't used it a lot, not because they don't think they have the authority, but because they haven't had the resources to go after some of these other pollutants. There are always petitions to use that authority to go after pollutants that we understand more with the science are posing a danger to human health, and the EPA doesn't get there very often. The fact that they chose to get there this time shouldn't, the fact that they haven't used it that much shouldn't be a reason why they can't use it now. And I think the dissent did an admirable job of explaining exactly why that's the case. And finally, the dissent made the fundamental common sense argument that, what planet is the majority living on? I mean, climate change is an existential crisis. This is not the time to be debating constitutional principles of administrative law. We need all hands on deck to address this problem, and taking away an important tool is just nonsensical. And they're right. It's not a legal argument, but it is a very practical argument about why the EPA should be allowed to do what they really need to do with respect to greenhouse gas emissions. So with that, maybe I'll turn it over to Ann to talk about what may or may not happen in Congress.
Thanks, Scott. Thanks, Howard. So I'm Ann Messnikoff. I'm ELPC's Federal Legislative Director based in DC. about 9 blocks from the Supreme Court, where all the action seems to be happening. So for Congress and where we are at this very moment when it comes to action on climate, the main attention is on what is called a reconciliation package. Just so we're all on the same page, a reconciliation package is a budget reconciliation package. And the advantage of a budget reconciliation package is that the Senate can pass that with a majority or 51 votes, and avoiding the 60 vote hurdle that applies to other legislation, hence all the conversations around filibuster, getting rid of the filibuster, reconciliation to sort of avoid that whole side of things. But it is also a limited tool. It is limited to raising money through changes to the tax code or otherwise, and then spending that money through adding funding to existing programs, existing policies. So it's not a cure-all, but it is a very effective tool. For much of last year, there was a lot of effort on putting together what was called the Build Back Better Act, which was a very large package that included those social programs, but also a very large climate package that included extending tax credits and updating tax credits for renewable energy, wind and solar and other. It included revising and updating tax credits for electric vehicles and charging equipment. It covered a very broad swath of programs that would generate action on addressing the climate crisis, reducing emissions, manufacturing, and otherwise. So it was a very important package, which the House passed in the fall. ELPC was very engaged in supporting many aspects of that package, including a real increase in funding for the Rural Energy for America program, which is in the Farm Bill, that allows farmers and rural small businesses to invest in renewable energy and energy efficiency programs investments. So, it was a sprawling package. We all know what happened to that package. It sort of met its demise in the Senate. We all know the role that Senator Manchin plays in this context. And sort of since the demise of the Build Back Better Act, everyone has just been waiting and hoping that Congress will pull something together to advance a really substantive climate package. We know that Senator Manchin and Majority Leader Schumer are talking, their staffs are talking. It's a very closed process. It is not, there is not a lot of information coming out of those conversations. I think people have been hoping that there would be an agreement in the early spring, and then before Memorial Day, and then before July 4th, and now just after the July 4th holiday, that they would have something ready to go. Word is, leaks out occasionally that they've reached agreement on the revenue raisers, sort of how much money they'll have to spend, that they're working through how that money will be spent. I think at this point, all we can do is hope that they'll reach agreement, and that the compromises or bad things that might be in that package don't outweigh the necessary spending on climate action that will be in the package. It is sort of a waiting game, but I think that as Scott noted, as Howard noted, action on the climate crisis is necessary, and getting this package going is critical. The window will close for action when they leave for August recess, and then come back for a short time in the fall to really manage appropriations for the next fiscal year, and then head off for election season. So there's not a lot of time, but I think we have to be hopeful that there will be a package, and that it will have generate some really important and aggressive spending and action on the climate crisis. As for sort of how we can manage some of the things that Howard mentioned or that Scott mentioned, how do can Congress amend the Clean Air Act to inject specific direction to EPA to act in the ways that the Supreme Court seems to be finding they don't have at the moment, wrongly? I think that's just going to have to wait. That's sort of a longer term project. It will depend entirely on the elections and whether the circumstances are such that we can open the Clean Air Act for amendment and do that successfully. Certainly doing that and ending up in a mess that further undermines the Clean Air Act is not where anybody would want to be. So that's something we'll just have to wait for. But in the meantime, I think we have to keep our fingers crossed that Schumer and Manchin can come together on a package, that package will be good enough. It's not going to be as big as the package we had in the fall of 2021. But there's a lot of space between what we had in the fall and where we'll hopefully we'll have success. So I will pass it on back to Howard.
All right, thank you, Scott. Thank you, Ann. I know there are a lot of questions people have. Let me see if the three of us can start answering some of what's been raised. Rick Duncan and Brittany Meyer raised the question of what happens to the Chevron doctrine. For those of you who are not environmental legal beagles, the Chevron doctrine is deference to administrative agencies, whether it's EPA, the FDA, the Securities and Exchange Commission, or others, in cases where Congress is not clear. The short answer is the Supreme Court did not really address the Chevron doctrine. Chevron deference will wait another case. If agency action is permissible and not constrained by the major questions doctrine, then at present, Chevron deference still applies. Now, that may be on the edge, and a lot of us look at Chevron deference being in play before the court, at least just court go there.
Yeah, let me just add one point on that. I think the Chevron doctrine is definitely at best on life support, if it isn't gone already. Nobody brought it up in this case. In all of the briefs that were submitted, I don't think there was really anybody that made a serious Chevron argument. The enviros and the people on their side didn't want to bring it up because they thought that would just give the court an opportunity to overrule it. And the industry didn't bring it up because they were the ones that were trying to overturn the rule. So they didn't want any kind of deference to the agency. But there were at least a dozen opportunities for the court to deal with Chevron this year, and the way they dealt with it was by ignoring it. So this may be one of those situations where a decision is essentially overruled by silence, that if it never applies, then it doesn't connect anymore. They probably will pick a case in the next year or two that will formally overrule it. They didn't overrule what's called the Our doctrine last year, which is the deference to agency interpretations of their own rules. But they almost did. They put so many limits on it that it's almost, I can't imagine really a situation where that kind of deference is going to apply anymore. And I think the same thing is going to happen with Chevron.
There are a couple of questions about what will happen in Congress, and could the Supreme Court's latest decision wind up being part of a compromise package that you're describing? Will this case give Manchin some political cover to support the Build Back Better program with climate provisions? What do you think?
I think the negotiations over the package have been going on for a long time now, with or without this decision. I'm no expert on what's going on in Senator Manchin's mind. I think we know certain things. He's not a huge fan of electric vehicles or expanding or increasing the tax credit for those. So, I think the parameters are sort of set based on the package that the House passed in the fall. There were a bunch of, that was a big package. I think elements of that will carry forward into this new package. It will be smaller than the 550 billion or so that was in the prior for climate. But I'm not sure that Joe Manchin was waiting for this, or this decision will sort of change his thinking about what he needs to do in terms of the reconciliation. I just think, and I see some points in the chat, we can't afford to wait. And that's true. And I think that there are other avenues for action. And certainly people can let their members of Congress know they want this, that they want a reconciliation package. They want bold climate action from Congress. But when it comes to how this reconciliation package will come together, there are very few people in that room right now. And I think hopefully Joe Manchin, whether this Supreme Court decision moves him or not, we'll get something.
Jeff Greenspan asks, if a carbon tax on generation is an alternative for the future? And I think the answer is yes, in the legal sense, Jeff. The court's decision wouldn't affect if Congress itself decided to adopt a carbon tax, because that would avoid the major question issue that was addressed by the Supreme Court. Scott, this one's probably for you. There are a number of questions about the upcoming Sackett case. The Sackett case is a Clean Water Act case involving the waters of the US standard. And the question is that maybe going to be another major question case? Is that going to be a case that takes on Chevron? What do you think?
Well, I mean, there are some potential parallels there. Just so people understand, Sackett is it'll be the first case argued in the next term of the U.S. Supreme Court. It's already been scheduled for October 3rd, first Monday in October. It is a case where what's being challenged are old definitions of the term waters of the United States. It really doesn't have a lot to do with the so-called clean water rule that was passed during the Obama administration. It doesn't have that much to do with the so-called dirty water rule that was passed by the Trump EPA. It really has to do with the rules that have been in place for nearly 50 years about what the scope of waters of the United States means, and that's what defines the scope of federal jurisdiction. The betting line is that there are at least 5 members of the court that are going to adopt a much, much more restrictive definition of that. Whether or not the idea of major questions or deference or Chevron come into play, I think remains to be seen, although it may well be just that none of those things will show up in the opinion. They'll just say, well, when Congress said waters of the United States, it really was thinking about traditionally navigable waters, waters where you can float a boat. It really wasn't thinking that much about things like wetlands and ephemeral streams. And it may therefore require EPA, if EPA is ever going to do rules on this, to adopt a much narrower version, which would reduce the scope of the EPA's authority over clean water. It would throw the ball back to the states, and the states are not picking up the ball. In fact, several states have adopted rules saying that if the scope of waters of the United States at the federal level is reduced, we're going to reduce our authority the same. So it means it won't be regulated at all. Although the justification from the court will be, this is something that belongs with the states, even though the states aren't showing any real interest in doing it. So I think it's the idea that you shouldn't adopt expansive views of agency authority is part of that non-delegation issue that I think drives things like this major questions doctrine. So even if it's not explicitly part of the opinion in the fall, it's going to be right underneath, I think.
There are a number of thank you, Scott, on the clean water side. And I'm trying to package questions together. As you can probably see, you're following the chat box. This feels like my law school class at the University of Michigan Law School, climate change and clean energy law, when it gets to some of the clean air questions people are raising. A number of you have been asking about, can the EPA require a cap on carbon for a particular coal plant within the fence line? Can the EPA require carbon capture and sequestration? And the answer is yes. At least with regard to this court decision, the court made pretty clear that the EPA had historic power to regulate within the fence line. And there is technology to do carbon capture. That's well known. The EPA knows it. Questions have been asked about, does the EPA have the technical capacity? And I think on this one, the answer is yes, they do. So following this decision, one option for the EPA would be to regulate greenhouse gases more directly on the power plant, require carbon capture, and that be done within the fence line. And that fits within the 4 corners of both the statute, as it was seen by the majority opinion in the Supreme Court, and it deals with the major questions topic. Ironically, what that does is provide less flexibility for coal plant owners and operators than the Clean Power Plan would have, which was designed to provide more flexibility. But yes, under this decision, EPA can do that. They have the technical capacity to do it. And some of the coal plant owners may well look at it and, the old line about sometimes you get what you wish for and it's not what you wanted. There's some political questions here that Ann, Scott, others you might want to address. Our colleague Andy Olson asks, to what extent was the Supreme Court talking about the perils and the realities of climate change? I would say, Andy, not much, not really. This is a legal analysis based on the major questions doctrine, and the court would see that as political. On the other hand, in Massachusetts versus EPA, the landmark climate change decision, there's extensive commentary about the coming threat of climate change and the impacts on all of us and on the planet. Some questions about what does Congress do now and what can people do? Obviously, we can lobby our congressionals. And do you see any sort of narrow, focused, tailored things that Congress could do apart from Build Back Better that would make a difference on climate?
That's a broad question. I think I would have to think that one through. I am sure that there are, the Farm Bill, will be up for reauthorization in the next Congress, and there is a lot of climate policy there. So there'll be opportunities to influence the Farm Bill, not that we want to wait till the next Congress. There are, significant funding in programs for the next fiscal year at EPA and otherwise. So ensuring that appropriations are high for all the agencies like EPA and others that have activities that can help in the climate space. I mean, that's important. I think making sure your members of Congress hear from you that you want them to support action on climate is helpful. I think I'll stop there.
Some questions from, I'll just go through a number of them quickly. Our good Indiana colleague and client, Tim Maloney at Hoosier Environmental Council, asks whether this is a sort of judicial activist decision the conservatives criticize. Yes, this is the height of judicial activism, overruling what's been done by a delegated agency, the EPA. Michael Courier asks, do we think the Supreme Court is aware that pollution doesn't abide by state boundaries? Yes, I'm pretty certain they are. Rahul Ray asks, will this West Virginia versus EPA case make coal plants more economical? I don't think so, and here's why. The Obama Clean Power Plan, which was at issue before the court here, was never implemented and it was never enforced. So it never really did make a difference on coal plant economics at present. However, the standards on sulfur dioxide, which causes acid rain, particulates, which cause smog and soot, NOx, which causes smog, mercury, which causes all sorts of fetal brain problems, those regulations are going forward. They require within the fence line technological controls that cost coal plant owners and operators money. Those are making a difference. Ellen Partridge, Susan Thomas, and others ask about what's going to happen next in the clean water context. Scott addressed that a little bit. With regard to the WOTUS, the Sackett case in WOTUS, there is some fear that that court might treat that as a major question. They may also look at it as a Chevron issue. But so many of the other clean water standards that US EPA routinely is supposed to regulate and enforce probably don't arise to the major questions level any more than the court would view regulation of sulfur dioxide that causes acid rain or nitrogen oxides to get up to that major question level. Twice in the opinion, the court refers to major questions involving extraordinary circumstances. Here, the court says a set of regulations involving greenhouse gases that have an extensive effect across the electricity sector and a major part of the economy reach the level of being a major question. But it's pretty clear that at least with regard to this opinion, the court isn't yet ready to say that all of the conventional rulemaking by the US EPA, or for that matter, the SEC, the FDA, the Consumer Product Safety Commission, and so forth, are all major questions that are to be handled by Congress. As Scott mentioned, that would be the so-called non-delegation doctrine. And it's at least apparent that other than Justices Thomas and Gorsuch, who filed a separate opinion, that the other 4 justices in the majority at least haven't indicated that they're willing to go that far yet, at least not in this opinion. Number of questions here about, go ahead, Scott, go ahead.
Just add to that, a case that might be interesting to watch, which I think might be the next one, it is tied back into climate, and it's the Securities and Exchange Commission's rule requiring greater disclosures on companies' climate issues. I think a lot of people have been thinking, and the challenges have already started, saying that that's beyond the scope of the SEC's authority, because there's nothing in the Securities and Exchange Act that says anything about climate. And I think that might be the next one. I don't think it's going to be in the area of sort of, I'm not sure it's going to be in the waters of the United States case, because ultimately that's about trying to reaffirm Justice Scalia's decision from 15 years ago, which was based on dictionary definitions, not on major question, not on Chevron, not on any of that. And I think that's what they're going to do again when it comes down to it.
You know, there are a number of questions. Reed McCaleb has one and others about how often does the Supreme Court invoke the major questions doctrine? The answer is not very often at all. This is really a newly discovered doctrine. One would call it judicial activism by the current court. This is not something that's been in judicial history in any significant way over the years. This is really activism by the conservative wing of the court to undo what administrative agencies are doing. Now, Chief Justice Roberts, in this opinion, may have tamped down expectations a little bit. You know, there are some, as we mentioned, that really want to open up a much more wider expanse of congressional and administrative agency decisions to the major questions doctrine. But by saying it was for an extraordinary case in the way it was framed here in Chief Justice Roberts's majority opinion, they do try to cabin it off a little bit. But let's keep in mind what one of the real world practical implications is of this. If you're representing a polluter in an environmental case, if you're representing a financial institution in an SEC case, if you're representing a pharmaceutical company in an FDA case, now you have an argument to go in front of a district court or a court of appeals for whatever regulation you don't like and say, look at the impact this has across a major economic sector. This is the major questions doctrine. The agency should not be permitted to act. And in today's way of litigation, you can expect that plaintiffs will go and try to find a friendly forum, a district court where they think there's a district court judge who might be, say, a Federalist Society member and appointee, try to get an injunction on a major questions doctrine claim before the district court, and then have it drag out before the Court of Appeals and ultimately the Supreme Court on a cert petition. Point being, even if the affected regulated industry here loses in the end, and the major question doctrine isn't applied, because it's only to be used in extraordinary cases, it's dragged out, it's stalled the regulation, it stopped progress from happening, and it's provided the opportunity to shift from the current administration to what some might hope to be a more friendly next administration, as we saw in the transition from the Obama administration to the Trump administration. You know, look for attorneys on behalf of regulated industries, whether it's pharmaceuticals, coal, financial institutions, to repeatedly invoke the major question doctrine from this decision as a way of delaying and stalling rulemaking by the federal agencies.
Yeah, it's been happening already, and the Fifth Circuit has been really at the front of that. And this decision obviously is going to just, provide greater assurance that that's a valid kind of an argument to make. This case, as the dissent pointed out, is the first time the phrase major questions doctrine has ever appeared in a majority opinion of the U.S. Supreme Court. The first time. It's never appeared before.
All right, a couple quick questions. I'm going to do sort of a speed round here because we're moving to wrap this up. A lot of questions about what will happen with major questions doctrine going forward. Scott and I have sort of answered that one. The answer is we'll see whether it's cabined off in the way that Chief Justice Roberts seems to be trying to do in his majority opinion, or whether it's used far more aggressively to stall, delay, and otherwise reverse regulatory actions by not just EPA, but other regulatory agencies. Questions about, does this case impact EPA's ability to regulate methane emission leaks, from pipelines and flaring activity? Probably not. That probably doesn't rise to the level, at least the way the Chief Justice's opinion sees it, of being extraordinary regulation, therefore triggering a major question, any more than nitrogen oxide regulation or ozone or sulfur dioxide would. If you get to that level, then everything, if you will, becomes a major question. And at least the current majority in the court on this opinion isn't ready to go there. Let me thank you all for joining us. This has been a whirlwind. It's obviously not good news. I'm not going to try to dress it up, and neither is Ann or Scott. It could have been more catastrophic, unfortunately, but it certainly is bad news. There's not a good silver lining. There's a lot to come. As I said at the beginning, there are more tools. We're going to use them. No one ever said it was going to be easy to save the planet. At ELPC, and we urge all of you, don't just agonize, innovate, litigate, advocate, keep fighting back, don't give up. Our planet and all of us literally depend on that. Let's save the planet in the courts, in the court of public opinion, and in the legislatures. We need to do it. And when it comes to climate change, we need to win for all of us. Thank you very much for joining today. More to follow. Join us at the next ELPC Thinks. Take care.